In the case of Dr. Wheatley, it was not $10, it was $164 million. So $164 million of his wealth could not be explained by his lawful income. And that.
Let me just repeat that. Dr. Wheatley said to the Integrity Commission that his medical practice was sold to an individual. He couldn't provide records. When the Integrity Commission did its own research, the name of the person he provided had been removed from Jamaica, either by deportation or extradition, 3 years before the transaction was alleged to have taken place. So that
the Director of Corruption Prosecutions has made a decision that Dr. Wheatley should be charged with 4 offenses. The most egregious of those offenses is the corruption offense of illicit enrichment.
The PNP has doubled down on its call for government MP Dr. Andrew Wheatley to be removed after the Integrity Commission reportedly recommended that charges be brought against him. At a press conference, PNP leader Mark Golding, supported by Julian Robinson and Cleveland Tomlinson, urged the Prime Minister to take action and remove Dr. Wheatley from his position.
The Integrity Commission, having conducted its extensive and thorough investigation, concluded that Member of Parliament Dr. Andrew Wheatley is in breach of the Corruption Prevention Act, in particular the offense of illicit enrichment. How did it arrive at this conclusion? According to the Integrity Commission, between 2013 and 2022, Dr. Wheatley, his total known lawful income amounted to approximately $187 million. His total expenditure and assets acquired over that period, over the same period, amounted to approximately $352 million. That's a shortfall of $164 million. So how you arrive at illicit enrichment, the determination of illicit enrichment, a formula, a simple mathematical formula is incorporated. Let's assume that your wealth over a period of time amounts to $20. The assets that you have acquired, the expenditure that you have made was $20. But your income over that specified period was $10. So you deduct your income of $10 from your expenditure or your wealth of $20, which would leave a difference of $10. That $10 cannot be explained by your lawful income, which means that that $10 is treated as illicit enrichment. In the case of Dr. Wheatley, it was not $10, it was $164 million. So $164 million of his wealth could not be explained by his lawful income. And that is why the Integrity Commission concluded that this amounts to illicit enrichment. Make no mistake, the Integrity Commission provided numerous opportunities for Dr. Wheatley to explain the source of this wealth. I read the chronology, I read the report in its entirety. There were several opportunities for him to appear before the Integrity Commission in the presence of his counsel to explain and justify his source of income. So he cannot provide an explanation that he did not have the opportunity to respond. The Integrity Commission was very extensive in the opportunities that it provided him. The findings are more serious than just the $164 million of his wealth that could not be explained by his lawful income. There were bank deposits that also could not be explained. According to the Integrity Commission's report, total deposits across his 4 personal accounts for the relevant period amounted to approximately $595 million. After accounting for transfers, interest, and deposits that carried a satisfactory explanation, the Integrity Commission was satisfied with the explanation provided for that. Approximately $168 million remain unexplained. In essence, deposits to his 4 bank accounts amounted to $168 million that could not be explained. Where have we?
I want to reiterate, reinforce, and to stand by the call made by the opposition leader for Andrew Wheatley to be removed from the cabinet of Jamaica with immediate effect. This is the first time that we have had a public official, and certainly a member of parliament, who has been recommended for charges for illicit enrichment, a very serious allegation and charge. But beyond the charges, I want to take you through the responses of Dr. Wheatley to the Integrity Commission. And it is important to note that this investigation started from 2021, 5 years ago. And if you look at the chronology, many opportunities were provided for Dr. Wheatley to respond to the questions, the queries of the Integrity Commission to provide clarification on the issues that arose. So we have had an investigation for over 5 years. I would say due process was provided to Dr. Wheatley over this period of time. And beyond the allegations, I want to look at the issue of his own credibility in the responses that he has provided to the Integrity Commission, because it goes to the heart of public trust. And I believe, based on the responses he has provided, he has lost public trust and credibility. And just on that basis, he should be removed from the cabinet. Let me take one of the findings from the Integrity Commission. The Integrity Commission asked Dr. Wheatley to provide information about the sale of his medical practice, Western Medical Center, for $13 million in 2013, which was paid through intermittent cash payments. Dr. Wheatley named the buyer, but he produced no receipts. The Integrity Commission independently established that the individual who was named as the buyer had been involuntarily removed from Jamaica, whether by deportation or extradition, 3 years before the transaction was allegedly to have taken place. Let me just repeat that. Dr. Wheatley said to the Integrity Commission that his medical practice was sold to an individual. He couldn't provide records. When the Integrity Commission did its own research, the name of the person he provided had been removed from Jamaica, either by deportation or extradition, 3 years before the transaction was alleged to have taken place. So that explanation was not just unsubstantiated. It was impossible. It could not have taken place. And the Integrity Commission rejected that. Let's take another issue that arose from the report. An investment scheme. Dr. Wheatley told the Commission he earned returns from a high-yield investment scheme called U-Win Antigua between 2007 and 2010. The Integrity Commission could find no evidence that this scheme existed. There were no records. But more importantly, the explanation or the records were not in Dr. Wheatley's own statutory declarations for the entire period. And he only raised this in 2024 when part of the investigation into illicit enrichment. So there is again an issue of credibility. Dr. Wheatley represents to the Commission one thing, and then on investigation, it is found that it is totally opposite. The third issue.
My two parliamentary colleagues have gone into some of the details of the Integrity Commission report concerning MP Andrew Wheatley, who is a minister of government. As a result of that extensive investigation done by the Integrity Commission, the Director of Corruption Prosecutions has made a decision that Dr. Wheatley should be charged with 4 offenses. The most egregious of those offenses is the corruption offense of illicit enrichment, which is part of our law, was brought into our law under the Corruption Prevention Act to give effect to our international obligations as signatories to anti-corruption treaties, which are global. It is absolutely untenable for the Cabinet of Jamaica to have a sitting minister who has been recommended to be charged with the corruption offense of illicit enrichment. That brings Jamaica's name into disrepute, both here and abroad. Furthermore, there are two serious charges relating to making false declarations, which is also a serious offense under the Integrity Commission Act and its predecessor, the Parliamentarian Integrity of Members Act. That prior to 18 was the law which required MPs and senators to file annual declarations. And it's important to note that what the Integrity Commission is saying is that the falsehoods in the declaration submitted by Dr. Wheatley arose both under the law prior to 2018, the Parliamentary Members Integrity Act, and the law that's existed since 2018, which is the Integrity Commission Act. So there is a long-standing pattern of these declarations not giving the true picture of the members' state of affairs. It's a statutory declaration is a comprehensive document. It requires you to disclose all your assets, personal or business, all your liabilities, personal or business, and all your income. Dr. Wheatley, manifestly, according to the report, didn't comply with those obligations, hence the recommendation that he be charged.